All right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the statewide training initiative with Florida Legal Services. We're excited to have you join us here today for Navigating Civil Appeals in Florida, a guide for public interest attorneys. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. You're going to receive a copy of the recording in an email from Zoom within 24 hours. If you don't see that email, I'm going to drop my email here into the chat just in case. Feel free to reach out to me if there's anything that you need. This training was approved by the Florida Bar for 1.5 general CLE credits and 1.5 appellate practice certification credits. I will announce the CLE code towards the end of the session. I will also drop it here in the chat, and it will also be included in the email that goes out via Zoom. Closed captions are enabled for anybody who needs them. If you are having any issues with accessibility or the captions, you can reach out to me directly. This training is also being co-hosted by the Public Interest Law section of the Florida Bar, also known as PILS. If you're not familiar with PILS, I encourage you to take a look at their website. They have a lot of subject matter areas and a lot of operating committees that are pretty cool. So if you want to learn more about PILS, please take a look at their website. And final are questions and answers. If you have any questions related to the presentation, please put it in the chat and we'll do our best to either address it while if the question comes up, or we'll try to address it towards the end if time permits. So before I introduce our speakers, I do want to do something a little bit different. I know Joan was not able to attend today, but I do want to give a quick shout out to Joan Bello with Bay Area Legal Services and Jeff Grable, because Joan came up and she connected me with Jeff, and Jeff connected me with Christine and Brandon. So special shout out to them. If you see them around, say thanks for this great training. And without further ado, it is my pleasure to introduce our amazing speakers today. I can't do them justice with a short bio, but if you want to read some really amazing bios, I would encourage you to go to their website. I'll drop a link here as well. So I'm going to give you a short version of this. Christine North has over 30 years of experience in appellate practice and civil litigation. She has represented clients in trial and appellate courts across diverse areas, including complex commercial, personal injury, employment disputes, and family law. Previously a staff attorney for Judge Chris Attenberg at Florida 2nd District Court of Appeal. Ms. Norris also shares the rules of general practice and judicial administration committee and serves on the ABA Litigation Journal editorial board. She is highly recognized in her field, holding multiple honors, including Lawyer of the Year for appellate practice in Tampa. Our other speaker, Brandon Breslow, is an accomplished trial and appellate attorney with experience in civil and criminal cases, including high-stakes litigation and appeals. Known for his work on complex issues, Mr. Breslow has also achieved successful outcomes for clients in both violent and financial crime cases. He serves as the chair of the Florida Bar Federal Court Practice Committee and is on the executive council of the Appellate Practice Section. Formerly a law clerk in the Northern District of Florida, his work is frequently cited by courts and law journals. So without further ado, it is my pleasure to pass it over to Christine. Christine, the floor is yours.
Thank you, Jorge, for that nice introduction. And we're really happy to be here today. Legal services near and dear to our hearts. We do a fair amount of advising or even taking on some pro bono cases here and there. So really appreciative of the work that you do and how important it is to our society. So we're going to try to do a full overview of civil appeals in an hour and a half. It's a lot of content. But we wanted to give you as much as we could. And we're going to primarily focus on Florida state appeals. There's a couple points in the presentation where we'll point out a difference in federal court. But when we talk about jurisdiction, and most of the slides are going to talk about state courts. And no appellate presentation on appeals would be complete without a beginning primer on jurisdiction. So we're going to start with jurisdiction. So the main premise for all jurisdiction is the Florida Constitution. And I think as lawyers, we get used to kind of looking at the case law first, but if you really have a jurisdictional question, you want to look at the Constitution when it comes to the jurisdiction of the courts. So county courts, the basis for the constitutional provision is there shall be a county court in each county. So that's kind of basic. The county court's jurisdiction is as prescribed as general law. So you'll see this as prescribed by general law in a few instances that we're going to talk about. And what that means is go look at the statutes. If it says as prescribed by general law, you have to find the statute that then gives the court jurisdiction. So in county courts, that's section 34.01 Florida statutes, which is entitled Jurisdiction of County Courts, and explains misdemeanors, municipal violations, actions at law, below certain monetary thresholds. Obviously, here you're going to include your landlord-tenant cases and your small claims cases. I know that you all see some of those. Those are going to be in county court. All right, then next level up, circuit courts. And circuit courts are covered in Article 5, Section 5 of the Florida Constitution. Those shall be a circuit court serving each circuit. Circuit courts, the Florida Constitution explains, have original jurisdiction not vested in the county courts. So those are going to be like writ jurisdiction, and jurisdiction of appeals when provided by general law. So again, that's your writs, mandamus, quo warranto, certiorari, prohibition, habeas corpus, all writs. We have that general law, right? So that's going to be direct review of administrative action prescribed by general law also. So we're going to look at statutes again here. Section 26.012 Florida statutes, the jurisdiction of the circuit court, explains actions that are not at law that are not cognizable by county courts, probate, guardianship, competency, cases in equity, including injunctive relief, and of course, equity includes your family law cases, felonies, the legality of taxes. So that's your, yes. All right, go to the next.
It's gone. Is it not?
Okay, sorry, that was the end. Okay, District Courts of Appeal, Article 5, Section 4 Florida Constitution. Appeals that may be taken as a matter of right from final judgments or orders not directly appealable to the Supreme Court or Circuit Court, including review of administrative action. Review of interlocutory orders to the extent provided by rules adopted by the Supreme Court, and direct review of administrative action as prescribed by general law. I'm going to, and then your writs again. So some writs. I want to take a minute here. So review of interlocutory orders to the extent provided by rules adopted by the Florida Supreme Court means that if you have an interlocutory, a non-final order, and you need to know if it's appealable, then your source is going to be the Florida Supreme Court. And we're going to talk about those types of orders next. Well, back one more, 1 second. The direct review of administrative action, I want to talk about that. We saw that in the circuit courts also. And again, both of those are as prescribed by general law. So if you have an administrative appeal, you need to find the law that tells you where that appeal gets filed, whether it be the circuit court or the district court of appeal. And then one more comment on this, appeals that may be taken as a matter of right from final judgments. So you have a right to appeal every final judgment in a civil case. Your first appeal is an appeal as of right. Further appeals are discretionary, but those appeals are almost always going to go to the district courts of appeal at this point. Okay, next. Florida Supreme Court. So the Supreme Court's jurisdiction is under Article 5, Section 3. And basically they take direct review, bypassing the circuit, the district courts on death penalty, bond validations, and statewide agency action related to utilities. Those go directly to the Florida Supreme Court. And then appeals from district courts that declare a statute or constitutional provision invalid. Really important part of Supreme Court jurisdiction here. This slide is about what we call mandatory Supreme Court jurisdiction. They must review those things. They must review the bond validations, the death penalties, and something that declares a statute invalid. What's next is what we call discretionary jurisdiction. The things that they can review, but they do not have to review it. They get to decide. District court decisions declaring a statute or constitutional provision valid. So remember, if it's invalid, it's definitely going to be reviewed by the Supreme Court. If it's valid, then the Supreme Court may review it. And then those decisions affecting classes of constitutional or state officers. District courts have decisions that expressly and directly conflict with another district court or Supreme Court decision on the same question of law, or is certified to be in conflict. Let me pause one moment here on a really important phrase here. Decisions that expressly and directly conflict on the same question of law. That's fairly narrow. A lot of people seek Supreme Court jurisdiction and saying, well, there's an apparent conflict between this and that. But if it's not on the same question of law, if it's not clear from the face of the decision itself, then that will not qualify for express and direct conflict. Decisions of circuit court or district court certified to be of great public importance. So if a circuit court or district court has a decision and they think that it really does merit someone, the Florida Supreme Court weighing in right now, they can certify that question up to the Supreme Court. Again, the Supreme Court does not have to accept it. And then questions certified by the U.S. Supreme Court or a Federal Circuit Court of Appeal. We have a procedure in which if a federal court is deciding an issue of state law, they can refer a question over to our Florida Supreme Court, and the Florida Supreme Court can decide under principles of federalism whether or not they want to answer that question. And then again, writs. You see writs at all levels: habeas corpus, mandamus, prohibition, quo warranto, all writs. I've seen some writs filed, like habeas corpus you see, and I think filed in all the courts. Mandamus, I think, is more common in the appellate courts. Prohibition is your writ for lack of jurisdiction, effectively, or for disqualification. So those are typically going to be in the appellate courts, usually district court.
So next, we're going to talk about appealable orders that are both final and non-final. Obviously, we can't cover everything under the sun, so we definitely want to point you in a few directions to be able to shore up some issues that you know will be able to be taken up. When we talk about final orders, we're talking about the orders that end judicial labor. The words in the order are important, but they're not always going to be determinative. So, for instance, an order granting a motion to dismiss may not be final if if the order itself does not finally dismiss that case. And what we're talking about here more generally is the order language, not necessarily what the court might direct at the hearing if there's a separate hearing on the motion. The orders granting a motion for summary judgment are not appealable if they don't actually enter judgment. So there's particular judgment entering language that the court should use at the end of a summary judgment order, or for it to be appealable, we'll have to enter a separate final judgment. Something important to note, my background, as Jorge mentioned, is a lot of federal space. But working with Kristen, one thing I learned recently is that an order is also final if it finally resolves the litigation as to a single party. So if there's a case where there's, for some reason, multiple defendants, but there is final language for a summary judgment to be entered against one of those defendants, as long as that resolves the litigation against that single party, it then becomes an appealable final order. Where there's a lot, where there's a list, while the first final orders are, based on the language, there is a list in Rule 9.130 of what an appealable non-final order is. And those are orders concerning venue, Most injunctive orders, so preliminary or permanent injunctions, granting, denying, modifying, continuing, or dissolving, all of those are immediately appealable. Orders determining jurisdiction, orders determining the right to an immediate possession of property, so they're in sort of landlord-tenant space, eviction space. Family law orders on immediate monetary relief, time sharing, that a marital agreement was, and the marital settlement agreement is invalid. And then this 9.130, I'll continue on in a second, but this does not include any of the criminal orders, which you'd see in 9.140. Orders determining entitlement to arbitration or appraisal under an insurance policy. So in that case where there is an arbitration clause, it's deemed to be valid or invalid, that's an immediate non-final appeal. Orders determining a party is not entitled to workers' compensation immunity. Orders deciding class certification, granting or denying class certification. If a governmental entity has taken an action inordinately burdening real property, determining forum non-conveniens. Orders that determine, sorry, one second. Orders that determine if a settlement agreement is unenforceable, set aside, or did not exist as a matter of law. Orders establishing permanent guardianship for a dependent child. Those that grant or deny the appointment of a receiver, or that terminate or refuse to terminate a receivership. Orders on the disqualification of counsel. Orders denying motions asserting immunity in a federal civil rights case, asserting immunity under 768.289, or sovereign immunity. Motions, these are newer ones now. This was within the last 2 years. Motions for leave to amend to assert a claim for punitive damages. And then orders denying a motion to dismiss on the basis of the qualifications of a corroborating expert witness, and that's under the medical malpractice space. And again, the orders that have added this to Rule 9.130 of recent are explained by the Florida Supreme Court. They're entered with opinions explaining kind of the scope of the rule to the extent that needs to be explained outside the actual rule itself. It's important to note here, sometimes loose language is used when you talk about moving for rehearing or reconsideration of a non-final order that's on this list. So rehearing typically applies only to the moving for rehearing on final judgments. When you're talking about this list of non-final orders, a lot of what you're dealing with are essentially interlocutory orders that are entered by the trial court, and they'll be moving for reconsideration. And reconsideration is one of those things where it's within the inherent authority of the trial court, and it's got a slightly different standard than rehearing. But you should know whether you title a motion for reconsideration or a motion for rehearing on a non-final order that's on this list, it will not hold the time for filing a non-final appeal. So you'll want to make sure that you proceed with the appeal from the non-final order that's going to be appealed without consideration of the reconsideration or rehearing motion. And then the appellate rules will explain sort of how you deal with the litigation of that rehearing or reconsideration motion concurrently with the appeal of the non-final order itself. And we'll talk a little bit about that, but it's a very specific area. There's also special appealable orders in probate and in guardianship. So they'll have a series of orders that finally determine a right or obligation, but they're not technically final in the sense of ending all judicial labor in the case. So for that reason, the rule provides a whole laundry list of what orders can be appealed. And currently we counted 25 of them, different types of orders. So if you're handling probate and guardianship cases, it's best to consult directly with Rule 9.170.
All right, so I'm going to transition to talk about writs, but first I do want to make one point that we see the list of appealable non-final orders, as Brandon pointed out, is sort of growing. More orders are being added to that 9.130 list. So I think that's something to watch. The more non-final appealable orders in a case, the longer a case can take and the longer the delay can be. And the harder, particularly on a plaintiff or the person pursuing the action. The other thing I would know is that just because you have an appealable non-final order doesn't mean that you have to appeal it at that point in time. you do not waive your right to appeal that order at the end of the case. And any order that's entered throughout the litigation can typically be part of an appeal of the final judgment. You appeal the judgment, but you can raise anything that happened in the litigation up to that point, subject to the rules that we're going to go over on preservation, things like that. So you don't have to appeal a non-final order right when it's entered, but it's sometimes an important option for you. When you don't have an appealable non-final order and you don't have a final judgment, then sometimes your remedy is through writs. Writs are called original proceedings, meaning that you actually file them in the appellate court. Again, we'll get through procedures a little bit later on how these two different processes work. But just a quick primer on what writs there are and what they might be used for. Writs of certiorari are the most popular, I would say. They're orders that depart from the essential requirements of law and cannot be remedied in a final appeal. Most often you'll see these used for certain discovery rulings. And I think the one you think about all the time is the cat out of the bag privilege ruling. If the privilege is breached, there's no putting the cat back in the bag. There's irreparable harm, can't be remedied on a final appeal. And then you have to show a higher standard than you do on appeal. You have to show a departure from the essential requirements of law. So writs of certiorari are probably what we see most often when an order is non-final and not appealable. Writs of prohibition, I mentioned previously, they're to prevent actions without jurisdiction. They're also commonly used to review orders denying just judicial qualification. Writs of habeas corpus in criminal cases, child custody cases, you know, the holding of the body. I haven't seen them used in child custody cases much in modern era, but I have at least once included a writ of habeas corpus in a child custody case. Writs of mandamus are if an official fails to take a mandatory act that is not discretionary. They have to do it under the law and they're not doing it. What I've seen this being tossed about as an option most in the context of requiring a judge to rule on something. Something's been pending and they have not ruled on it, and they have a mandatory we can't say that they have to rule a certain way, but we need a ruling. And so we have debated but not yet filed ourselves petitions for writs of mandamus to try to push the court to enter a ruling. Obviously, you know, it could be fraught with a little bit of danger there. I forgot, it was in a prior slide, but I forgot to put here writs of quo warranto, probably because I've never used them. And so then I had to remind myself what they were. It's challenges a person or corporation's right to hold a public office or corporate position. So very rare in my practice, but maybe there's some need for it out there. And then there's an probably even rarer writ called all writs. And I've used this once, and that was because we had an oral ruling in a custody case. We did not have a written ruling, and you cannot appeal until you have a written ruling. And so we had to use all writs to seek review of the non-final, non-written ruling that the judge made. So it's a little bit complicated, but it's basically if all else fails, but the court should have jurisdiction to review something, then all writs is your answer. Want to talk a little bit about the grounds for appeal. And basically, when I talk to clients about appeals, I give them this sort of framework. It's a little simplistic, right? But I think it covers a lot. When I look at an appeal, I'm looking at three potential grounds, three kinds of rulings that the court could have made. Legal errors. The judge just applied the wrong law to something, didn't decline to apply the correct law. They are errors that are based on a mistaken view of the law. Those are really, for an appellant, the keys to trying to get the best standard of review, which we'll talk about. So really, if I'm thinking about taking on a case, I want to know, is there a legal error that I'll be able to latch onto? The second type of ruling are abuses of discretion. So in your family law cases, judges have a lot of discretion on how much alimony to award, what the time sharing should be, how to balance the different interests. These decisions that are made by judges based on a balancing of factors are typically discretionary decisions, and they're only going to be a grounds for appeal if you can show an abuse of that discretion. And then rulings on the sufficiency of the evidence. Now, you'll see this most often in civil cases, not so much family law, although I've seen it used before. But did the court enter a summary judgment? Did they enter a directed verdict, finding that there was just no competent evidence to support a verdict? So those are the three things we kind of look for in an appeal as to what kind of decisions are we going to be looking for review. So a few rules then. The next things I'm going to look for. Any error has to be preserved for appeal, meaning that the specific argument has to have been made to the trial court and the trial court ruled on it. We're going to talk in depth about preservation of error a little bit further, but basically my appeal is most likely to succeed if this argument was made to the trial judge and the trial judge, decided against it. Clearly. Evidentiary rulings must typically be preserved for appeal by a contemporaneous objection. So you want to make sure that you are objecting. And again, we'll talk more about this on the preservation of error. So we want to show there was preservation. And then in an appeal, you'll also have to show that the error was harmful to you. Right? It doesn't matter if the judge admitted certain testimony, if that testimony really just had nothing to do with what the jury ultimately decided. So the appellate court is looking for, how did this error potentially affect the ruling? If it looks like it didn't, then they will not reverse. But if it looks like it had an impact on the case and may have affected the trial judge or the jury, then that will be a basis for reversal. And that takes us into the related standards of review. And so I've talked a little bit about this already, but every case that comes up to the court's first, to an appellate court, the first thing the court has to think about is, what is the framework within which I'm looking at this issue? And those are standards of review. And again, this is very simplified because we're trying to give you sort of clear direction. And there's lots of gray areas that come up. But basically, we have three main standards of review. The first is de novo. So de novo is the standard of review for those legal errors that we talked about, right? The judge has made an error of law. And so now we want to have the appellate court look at it. And the appellate court says, well, we can read the law just as easily as the trial court can. So we're not going to give any deference to what the trial court ruled. We're going to look at the law and decide what the law says and how this case should be resolved. Then you have your abuse of discretion. Again, we talked about these discretionary rulings. And that will only permit reversal. The appellate court will look for whether no reasonable judge would have ruled the same way. So it's a hard hill to climb if you're the appellant, to show that no other judge who is reasonable would rule this way, but that is the standard for your discretionary rulings. And then competent substantial evidence. If we're looking at, was there enough evidence presented to survive summary judgment, directed verdict, to support a finding of fact? We want to look, is there any competent substantial evidence? It's funny because that word substantial, they use the word substantial there, but in fact, if you read some of the case law, competent substantial evidence is, any evidence that will reasonably support the findings. So it's a little broader than you might think.
So next, we're going to talk about preserving the issues for appeal. Except when you're dealing with fundamental error, which I'll talk about in a second, appellate court cannot consider any ground for objection that's not presented to the lower tribunal to make a ruling on. It sort of comes from an instance of fairness. Appellate courts don't consider their cases of first review, except when it's fundamentally erroneous. But also, this rule is meant to give the trial court a chance to essentially decide an issue, so that an attorney cannot just sit and say, well, there's error, I'm not going to raise it until an appeal that goes against or from an adverse decision. In federal courts, you'll hear fundamental error called plain error. It essentially means the same thing, but fundamental error in civil cases, Kristen calls it a unicorn. I think that's a fair description. I can't recall a civil case, where they have deemed something fundamental error. It exists out there still in theory. And the Florida Supreme Court or Florida appellate courts haven't shut the door on it entirely. But I think if you're appealing an issue that has certainly not been preserved, to deem it fundamental error would certainly be an uphill, if not impossible, challenge. So there's a couple steps to preserving errors for an appeal, and that typically starts with the pleadings. So for example, if you have a case where your entitlement to attorney's fees is based on a statute or a rule, and you know you're going to plead claims that will allow for attorney's fees if successful or if they're warranted, they have to be pled. Essentially, this is an important preservation rule, because a court will eventually decide whether there's entitlement. If the fees have not been pled, there is no entitlement. And so therefore, you can't appeal the lack of entitlement if the attorney's fees were not pled in the first instance. And there's other instances of that too, where the courts will look back at, well, was this theory pled? It was an error to not let this testimony in as to an unpled theory. And this, therefore, it will shut the door on a preservation alone. The objections to failure to satisfy conditions precedents must be raised with specificity in the responsive pleading, so the answer or an emotion. Again, that's also needed to preserve the issue about conditions precedent for an appeal. Issues that are not included in a pretrial order. So in most cases, if not all of them, you'll have to do a pretrial order or some sort of pretrial stipulation with the other side of the issues to be decided. And when an issue to be decided is not included in that order, it may be waived. Depends on the process for the trial itself. If you are going to object at trial to any unpled claims or defenses, you must do so because otherwise it may be deemed to have been tried by consent, which means that if an attorney sits and allows unpled testimony on an unpled theory and hopes to just deal with it at the charge conference or some other special jury instruction, that it's probably going to be deemed waived. So you must preserve the argument that it is an unpled theory at the outset of the trial, if not during the trial itself when any testimony came in. It's really important to do that because, as we know, sometimes cases grow and grow and grow. And so when you're talking about testimony that it goes beyond the pleadings itself, it's better to deal with that at the outset when it first comes in, so it can sort of change the course of the trial back to what is actually in the pleadings. It's also important to raise legal issues in pretrial motions in limine, Daubert motions. We have seen appeals from the denial of Daubert motions because they're untimely. So when you're dealing with experts, and the case with experts, and there's been expert depositions months before trial, and the movant files the Daubert motion 4 days before trial, a day before the pretrial conference. The appellate court said, at least one appellate court, the first DCA has said that is untimely to file a Daubert motion that close to trial or at the outside of trial, and that it was not an abuse of discretion to deny it on that basis. So you should be careful, kind of coordinate with your pretrial scheduling order as to when sort of expert depositions have been held. And then when you move for Daubert motions, we're seeing a lot of trial orders include a Daubert deadline anyway, which is good. So if there is that, certainly abide by it. But it also preserves the issues neatly for an appeal, because it will be a definitive ruling, especially if it's a motion to exclude under Daubert or a motion in limine and it's been deemed excluded. We'll talk about what to do in that instance in a second, but that's obviously a way to get a definitive ruling up front. Next, so you're in trial, and you have to know what to do at this point to make sure the issue is properly preserved. Obviously, as Kristen already said, make a timely contemporaneous objection at the time of the alleged error. So if it's an improper argument, object. If it's a testimony that should be excluded, object. Bring it to the court's attention, state the legal grounds, and if there needs to be a sidebar at that point, or if it's a non-jury trial, if it needs to be argued at that point, then that is the time to do it. That will advise the tribunal of the basis for the objection, and will obviously allow the appellate court to intelligently review the decision made by the trial court based on those legal grounds. For an argument to be heard on appeal, it must be the specific contention asserted as a legal ground for the objection, exception, or the motion below. So, for instance, if there is testimony that should not have come in because it was excludable under 90.403, for instance, or excludable under a certain as hearsay, and the argument in response to that is based on that specific objection in the trial court, and the court rules, and there's an appeal from that, typically the appellant cannot argue that that testimony should have been excluded for other additional reasons that weren't raised below, because again, it goes back to what the trial court ruled at that time and had the opportunity to address. There's a different standard for when the appellee is arguing that something was properly excluded or properly admitted. They can argue tipsy coachman at that point, that it was correct ruling, but maybe for different reasons than what the trial court ruled. But when you're talking about the preservation for an appeal by the appellant, it should be based on the argument that was made in the trial court, and that the rest were not presented to the trial court for a ruling. This rule does not mean that you can't rely on additional legal authority. There is a difference between raising additional arguments and raising additional authority, and that's a rule both in Florida court and federal courts. So if you have cases, if there's an argument on a motion or it cites certain cases, and there is, especially if there's subsequent authority after the motion's decided, but based on you retain appellate counsel, or you collaborate with coworkers on an appeal, and it raises additional legal authority, that's certainly not a new argument, and that usually is permissible. That's just a distinguishing between the additional authority that's been cited and the additional argument. Preserving errors in jury selection is certainly a different category altogether. There are specific objections that must be made, specific rules that must be followed. For instance, if you're denied certain peremptory or if you're denied a certain cause challenge, you have to use a peremptory challenge. There's all of those. We will not be able to get into those in the 90 minutes we have here today. But if you're dealing with errors in the jury selection process, there are additional resources we hope to provide at the end that will help with that, along with other specific areas for preservation. It's important from a preservation perspective to have a court reporter at every substantive hearing so that you can show you properly preserved the errors. There may be instances where motions are set for hearing and there's just not a thought ahead of time of who's going to provide the court reporter because it's multiple motions that are set. You should always check ahead of time that a court reporter will be there to make sure that there is a transcribed record for the appellate court to review on the specific arguments being made in the specific rulings. That goes to what we'll talk about later in this presentation, which is that ensuring your record is complete. Everything that is submitted to the trial court must be in the court file. We deal with this a lot where if we're having hearings, particularly Zoom hearings, there's a distance between what might be in the court file and what is presented to the judge. And sometimes the distance is just a matter of timing. We've seen clerks of court where something is filed, but it takes 10 days, 5 days to get to chambers. And so things that are immediately filed before the hearing, we're not ready for the judge to have for the decision, but also the reverse is true too. Things that have been provided to the court, whether it's evidence, supplemental case law, whatever is done in support of your motion or in support of your case, you must make sure it's in the court file. When you're dealing with video depositions that have been played, and when additional deposition designations at trial or even previous testimony designations, whatever, it's going to be presented as substantive evidence, you must make sure that there is a real live transcription in the court record by the court reporter in real time so that it can go into the trial transcript itself or hearing transcript. It's also important, this is sort of trial advocacy 102 probably, to describe nonverbal events that are going on with testimony. So sometimes witnesses will get carried away, and it's obviously our job as attorneys to say, well, you're describing something as quote unquote this big, what does this big mean? Or just sort of the characterization of what the witness is describing, make sure it gets in the court record too. To have an issue preserved for appeal, there obviously must be a clear ruling. So it's important that you get that clear ruling in the record. We see this where there's an objection to one piece of testimony. There's a sidebar or conference about the ruling on that objection to that piece of testimony, and someone asks for a standing objection to anything under the sun at that point related to that objection, the objection that's been made and ruled on. And the rule in the case law is that for a standing objection to work, it must be a definitive ruling on all of the issues that are being appealed regarding that testimony or that issue generally. We always advise trial attorneys to be aware of standing objections, because what you might think in the moment is related to that first objection, and then there's additional testimony on it that could be argued as admissible for additional reasons, has never been objected to because it was relying on the standing objection. So when in doubt, object again. And this also comes up with motions in limine too. Sometimes motions in limine are resolved with trial judges saying, well, let's see how the testimony goes. But the arguments are in the court file. They were made to the trial court, and the trial judge just says, well, let's see how the court goes, or let's see how the trial goes. And that's not a definitive ruling. So if it comes up at trial, object. If it comes up later in the testimony, but under a different, different verbiage or a different reason to object, to exclude it, object. That will make sure it is crystal clear that this issue has been preserved.
I want to divert just for a minute. Randall put a good comment into the chat saying that effectively fundamental error would be found if a court lacked jurisdiction. I think that's correct. If a court lacks jurisdiction, subject matter jurisdiction in particular, that can be raised at any time. So I guess I don't always think about that in terms of fundamental error, and it may not always be talked about in that context in the case law, but of course, any lack of subject matter jurisdiction can be raised at any time. And if an appellate court finds that there wasn't jurisdiction, it will reverse. It's not going to worry about the preservation aspect of that if there's just no jurisdiction. So I think that's a good point. I'm going to talk about a couple of more fine points on preservation of error. So one is you're at trial. You've made an objection to testimony that unfortunately the witness blurted out. You've made your objection. The judges sustained your objection, but that is hanging out there in front of the jury. Now, this is not going to happen as much in your judge trials. They'll just tell you that they know what's admissible or not admissible. But in a jury trial, you're really concerned about that. And so if the damage has been done, then it is also important for preservation that you move for a specific remedy. Judge, can I move to strike that? Tell the jury to disregard it. Judge, can I move for a curative instruction? Or if it's serious enough, a mistrial. Now, obviously, the practice point here, you never move for a curative instruction that's only going to make it worse. You know, they say when you're correcting kids and you say, no, don't do this, the first thing they think about is the thing that they're not supposed to be doing. So you don't always want a curative instruction. It might make the matter worse. So think about that, but you can ask for a mistrial. You can ask for a motion to strike. Don't ask for a mistrial you don't want. That's my second practice pointer. Check with your client, make sure you really want that mistrial and to try the case over again, because you have to be careful what you wish for. If you are attempting to present evidence and the opposing party successfully objects, you must present a proffer of what that evidence would show unless it's perfectly clear in context. I mean, it's obvious sometimes if you've asked a question and you're asking, you know what the answer to that question is going to be, and it's clear to everybody at the time. But if you're asking for a line of questioning, well, how far is that questioning going to go? What do you think you can actually get in to evidence? Those are the times that you're going to want to put in a proffer. And that's important because of the harmful error, right? The appellate court needs to be able to see if you had prevailed, what would the trial have looked like? And would it make a difference? So you want to also explain at that point why the evidence is relevant and admissible, make your case on that, but then show exactly what you would like to proffer. Proffers can be done sometimes in writing. You can proffer some things in writing. Sometimes you'll have courts say, well, you can make the proffer outside of my presence. I don't like that, but I realistically understand that you can't tell the judge that they have to stay in there on the bench while you're making your proffer. So if you have to do it without the judge there, that's fine. If they said, no, I've ruled and it doesn't matter what your proffer is, that will preserve it. But hopefully your proffer is to show the judge, to have them fully consider that testimony. So proffers can be important part of preserving your error.
Kristen, I'll add something. Part of the reason we're spending so much time on preservation is that obviously it's necessary for an appeal, but we're seeing that the appellate courts are starting to add this as a requirement to the briefing rules. So the 6th DCA, when it started last year, was it last year or the year before? I can't remember. Time all runs together. But when the 6th DCA opened its courthouse doors, the very first administrative order that it entered was additional briefing requirements. And one of them is commonly referred to as a statement of preservation. Tell us in your initial brief, where in the trial transcript, where in the appendix or the record, are we going to see the objection being made, the argument being presented, and the ruling on those arguments? And it's supposed to be done in a very non-argumentative manner. It is just so the trial court can easily check the box of this is preservation. So I just wanted to make sure that point is clear as we continue on to yet another preservation slide.
All right, so that is a great point, because we are seeing that if they're not going to require it in the brief, they may ask you about it in an oral argument. So to preserve a sufficiency of the evidence argument, so again, this is mostly going to be with your jury trials, but I have seen this used in family law cases and other cases. You want to make a motion for directed verdict. In federal court, we call it a motion for judgment as a matter of law. At the end of your opponent's case in chief, so they rest, you're going to make that motion. And then again, you want to renew it at the close of the evidence. And in your motion, I would say you want to also, that's kind of a trigger point at trial for you to also consider what other stuff went wrong that you want to talk to the judge about. So take a minute at that point to incorporate other previous arguments you want the judge to consider. Renew any motions for mistrial. Those close of evidence moments are a good point for preserving error. The other thing I would say about that close of evidence moments are sometimes an error happened, some kind of testimony was introduced and you objected at the time and the judge didn't think it was that big of a deal. But then there was another objection because something along those same lines came in, and it starts to crop up, and it starts to be clear how prejudicial that evidence is, and maybe the judge even backtracks. So this is a point for which you can kind of compile all that and say, well, judge, remember these three things happened, and together they mean I should get a mistrial now, or whatever relief you're looking for. Jury instructions, again, so we're talking about jury cases here. If you're seeking a specific jury instruction, you have to present it in writing, and you have to be sure it complies with the law. If it departs from the law in some manner and might confuse the jury, it will be properly denied, even if there should have been some instruction on the topic. And then conversely, if you're objecting to a proposed instruction, you probably should consider writing your own. If it's something the jury should be instructed about, write your own. That is the way that you think it should be. Give that judge an option, because sometimes the appellate court is like, well, you didn't give them a better option. You argued against it, but you didn't give them a better option. So, affirmed. So keep that in mind. Okay, verdicts. Again, still with the jury here. Carefully consider the form of the verdict that you want. Do you want special interrogatory verdicts? If you do, you have to request those. Do you want the jury to answer a series of questions so that you know their reasoning step by step? And there's a lot of strategy in that, for reasons I'll get to at the end of this slide. You want to know if you want to be able to see if the jury got something wrong, then you might want the interrogatory verdict. If you think the jury might be on your side and you don't want to actually spell out exactly how they came to the result, you don't want one. You want more general verdict. So you're thinking about, is the verdict form going to hide what could potentially be harmful error that I'd like to be able to show in appellate court? Will the jury's answer reveal the bases for their awards and how they calculated them or came to the figures? Present your requested form in writing, just like with the jury instructions. You have to have presented the option. Discuss it during the charge conference. And again, if you're on the defense side and you object to the plaintiffs, then make sure you have one of your own. When the jury comes back, you want to look at that jury's verdict form pretty quickly. There's a very fine distinction made in the case law between inconsistent verdicts where the jury makes two findings that really cannot be reconciled with each other no matter what, and then inadequate verdicts, which are, well, there was evidence of an injury and future medicals, but they didn't give any pain and suffering. Is that inadequate? Is that inconsistent? There's beyond the purview of this, but an inconsistent verdict, if you want to preserve that, you have to say, judge, this verdict is inconsistent. I want the jury, before they're released, I want them to go back and correct it. Now, again, strategy, right? You might be not thrilled that they didn't give you one, category of damages, but you might not want to have a new trial either. So this involves a lot of strategy at the point that the jury returns with their verdict and consideration. And then some of the reasons we talk about this is the two-issue rule. So in state court, I have a jury's verdict. It's a general verdict, finds liability. And there were two ways that they could have gotten to that liability finding. And I don't know exactly which one because it's a general verdict. And my challenge on appeal, I only really can attack one of those bases. Well, then the case will be affirmed. As Brandon mentioned, it could be right for the wrong reasons, and I can't attack the other bases. In federal court, it's actually the opposite. If you can prove you can prove one theory was wrong, then you can get reversal. But in state court, the reason you're looking at whether you want an interrogatory verdict is if you want to be able to challenge different bases that the jury could reach a result. All right, and then preserving issues for appeal, we're going to talk briefly about post-trial motions. post-trial motions are not necessary to preserve errors that you've already preserved. You made the objection at trial, you moved for a mistrial because of a clear ruling. There's nothing more for you to do if you've made a motion, it's been denied, you've objected, it's been overruled. Those things are preserved. So you don't need to file a motion just to like recap all those things that the judge got wrong. And he might not like it, he or she might not like it if you do anyways. So sometimes you want to file those motions to help kind of crystallize your arguments, or to show the pattern. Like I was saying, something at the beginning of the trial didn't seem that bad, but it built up, and then maybe the judge can now see the error of the ways. So those motions may help you in those circumstances. On the other hand, one of the things we always talk to people about when they talk about wanting to do a rehearing motion is, if the court's rulings weren't great, maybe they didn't really explain, or they explained very poorly what their reasoning was, and they're preserved. If we file a motion for rehearing and raise those, maybe they just buttress those rulings and they make them harder to attack. So we do look at that when we're thinking about whether or not to do a post-trial motion. An order granting a new trial is appealable in state court, and it must include findings. So if you win a new trial, that can go up on appeal. You wouldn't think it's considered final, right? Because you're going to have a new trial, but it is considered final. But to grant it, that court has to make specific findings of why they're granting the new trial. Errors that appear for the first time in a judgment should be brought to the court's attention. And I point this out because, again, if it appears for the first time in the judgment, let's just say it's a family law case, and for the first time the judge makes a ruling. Really, nobody really argued that. It happens to be an error. Maybe they're just mistaken about something. Your inclination may be, well, it's an error. You didn't have to preserve it. It first came out in the judgment. And traditionally that's the rule, that if an error appears for the first time in the judgment, you can appeal it. If it's sort of a surprise. However, the courts are kind of catching on to this now. And so recently amended Rule 1.530 and 12.530 to require that you do preserve an argument that the court didn't make findings it was required to make. So what was happening here was, let me just say, I know happening in quite a few cases, an order on attorney's fees in a family law case. In fact, I saw one of these, an appeal of an order granting a party $10,000 in temporary attorney's fees, and it didn't include the findings that you need to have on reasonable hourly rates and anticipated hours. There was no question that that $10,000 was, probably a drop in the bucket, quite frankly. Probably would have been sustained based on the record on appeal. But there were no findings, and the case law was pretty clear, it had to be reversed for just that reason. And I think appellate courts felt like that's a waste of resources. It's something the judge could and should have fixed if they were notified of it. And so there was already some rumblings in some of the case law, like they should have brought this to the judge's attention. If it looks like it's just an error that the judge maybe did, mistakenly, and you haven't given them a chance to correct it, it's going to look bad. If it's a lack of findings, you have to preserve it by rehearing. And again, post-trial motions can be productive in setting up the issues on appeal. Like I said above, it can crystallize kind of what the thrust of your arguments will be for why this result was not fair and right under the law.
We're done with preservation, I promise. We're going to go to the key stages in the civil appellate process now, and that's going to start with the notice of appeal. So it's due within 30 days of rendition of the order on review. And if there's any question about when an order has been rendered, you'll look at 9.020H to define rendition. This is a hard deadline. Do not miss it. Bears emphasis that this cannot be moved. So please make sure, like I said, if there's any question about when an order will be rendered, that you err on the side of caution and file the notice of appeal slightly early, or for the benefit of the doubt, the earlier deadline, rather than any potential later one. The notice has certain requirements in its form. It has to state the name, the date, and the nature of the order being appealed, and it must attach a copy of the judgment being appealed. You can explain in the notice the timing of any rehearing motion and attach the rehearing order, because a properly filed rehearing motion for a final judgment will toll the time for an order to be rendered. So, and that also applies to certain post-trial motions after a jury verdict's been returned, and there's been some maybe intermittent final judgment. So for instance, you have a jury verdict, you have a final judgment, and then a properly timely filed motion for mistrial, motion for directed verdict, motion to amend or alter the judgment. There's rules regarding how all of that possibly impacts the appealability of a final judgment in terms of timing and the timing of the notice of appeal. So if that plays into when your notice of appeal is filed, you want to explain that in the notice itself to make sure that the court is very well aware that this is a timely notice of appeal. It is filed in the trial court, on the trial court clerk's docket, just like anything else in the case, with the filing fee for the appeal to both the circuit and the appellate court. If they're going to be a cross appeal, the filing of the notice of appeal will trigger a 15-day deadline to file the notice of cross appeal. When you're dealing with writs, there is no notice of appeal. The first filing, it's an original proceeding in the appellate court. The first filing is the petition for the writ. The timing of when a writ has to be filed depends on the type of writ that you're proceeding or pursuing. So petitions for writ of certiorari must be filed within 30 days of the order. Others have no hard deadline, but the case law, as well as just judicial practice preferences, are that attorneys don't sit on the filing of a writ for some strategic reason or delay it unduly. And so our recommendation is, if there is a ruling that is subject to a different writ, not a certiorari writ, but like, for instance, a writ of prohibition on a motion to disqualify a trial judge, or some other reason regarding jurisdiction that prohibition would remedy, then it should be filed within that same 30-day period. And when we talk about the form of a brief, very much the petition will follow that form. So the two will coincide. It's not just a single page like a notice of appeal. A petition is substantive. It has certain requirements and must include all the arguments. And so you'll want to make sure that the actual petition itself is ready to be filed within 30 days. The petition, as I said, is filed in the appellate court as an original proceeding. It's not filed in the trial court. There's a lot, as I mentioned earlier, about what happens when you're appealing a non-final ruling, and that goes to writs too. An appeal will typically deprive the trial court of some of its jurisdiction. Writs generally will not do that. There's certain rules about if a petition's been filed and the appellate court issues an order to show cause, whether that will end jurisdiction of the trial court while that petition's pending versus just an order directing a response. So you'll want to look once the appellate court, if the appellate court does issue an order to show cause or order directing a response, whether the trial court's jurisdiction is lacking at that point to proceed with other matters that aren't going to be subject to the writ that's being challenging a certain ruling from the trial court. There's sometimes a phrase thrown around when we're talking about this called concurrent jurisdiction. So what the trial court can continue to do during an appeal, whether there's a stay and then the action that's sought to be taken in the trial court will depend on what the trial court's concurrent jurisdiction is. We're going to keep them beyond the scope of this presentation, but you're going to want to keep an eye out for these issues if you think that this is a case, particularly a writ, where there's going to be additional proceedings while the writ or while any other appeal is pending. So for the example, this comes up in family law cases. There are actually actions that the trial court can take to protect the parties as part of its jurisdiction, even while there is an appeal or a writ pending. So it is a concurrent jurisdiction is something you should certainly keep in your lexicon, so to speak, but you'll want to make sure that it's being exercised properly while there is an appeal or while there is a writ pending. After you file the notice, the priority changes to preparing the record on appeal. So as an appellate, the burden is on the appellant to provide the appellate court with a record that will show reversible error. Rule 9.200 will govern the record and explains what the clerk will automatically include, and you must file designations to the court reporter to arrange transcripts to be sent to the appellate court as part of the appellate record, and then directions to the clerk that can either limit or add to what 9.200 explains will be automatically included in the record. When you're talking about this, we'll talk in a little bit about motions to supplement the record. But when you're considering what should be included in the directions to the clerk, you want to consider what will not make the appellate record so overly burdensome to point out what is the error on appeal. If you know going into an appeal that there's a single pretrial ruling and that's all that is to be appealed, then it's not necessary that every pretrial hearing end up in the initial designation of the record, or every transcript from every pretrial hearing end up in the initial designation of the record. But that's a judgment call, and we'll talk about what happens when you run into an issue where you need to supplement later or the other side needs to do cross designations. In the alternative to the preparation of record, there is a procedure mentioned in the appellate rules about a stipulated statement to account for a lost transcript, but it's very rarely successful. We just have not seen it be done, not because it's improper to be done, just that it's very difficult to account for that lost transcript. So again, make sure you're hiring a court reporter, make sure it's a reliable one, and that this transcript can be recovered when it's necessary. Like I said, either party can move to supplement the record as the appeal is pending because the record's been completed, but you realize that, hey, this additional transcript or this additional notice of filing is necessary. Sometimes all the exhibits don't end up in the record. We often see motions to supplement the record when there's audio or video files that are on a CD that haven't been sent to the appellate court properly. So those are instances where we've seen a motion to supplement the record can be very helpful. The motion is filed in the appellate court, but the order from the appellate court typically granting that motion will require that you file amended designations or a certain designation with the trial court. In writs and in some non-final appeals, there's going to be no record prepared by the clerk. And so in those instances, you'll file an appendix that comports with Rule 9.220. And when you do that, there is certain requirements about how the formatting of the appendix, about what can be included in there. And so you'll want to refer to 9.220, but make sure that all of the relevant documents for the non-final appeal or for the writ are included there. Thankfully, when we talk about non-final appeals and writs, they're typically single issue cases, appeals to be decided. And so it's usually, I emphasize usually, not overly burdensome to get an appendix together. It just has to be formatted properly and transmitted to the appellate court properly. When we think of appeals, usually there's not a heavy motion practice, but sometimes motions like a motion to supplement the record, motions for attorney's fees, motions for extension of time, those are necessary parts of the appellate process. So some things to keep in mind are to check the appellate court's website and the administrative orders on their procedure for filing motions. Sometimes they will vary depending on the appellate court. Now, when you're dealing with motions for extension of time, in most cases, there are exceptions for urgent cases, emergency appeals, that extension of times can be done by stipulation. So it's usually called a notice of agreed extension. Each DCA has its own administrative order of how long, how many days of an extension you can get in filing an initial brief or answer brief or a response to a petition or any reply. And they vary from anywhere, I think, from 30 days by agreement to 90 days. So check the administrative orders on notices of agreed extension to make sure that, one, it complies with your case, and then also your type of case, but then also that you're not going over that deadline. We've also seen a growing number of courts that once you get to the deadline, the maximum number of agreed extensions under the administrative order, it's typically very difficult to get an extension beyond that, barring some urgent, extraordinary circumstances that just were not foreseeable when the initial extensions were taken. Motions for attorney's fees must be filed by the due date for the reply. So that's going to be based on the timing, which we'll get to later in the presentation. A matter of practice, if you're going to pursue attorney's fees and it's been decided that you'll pursue them on appeal, it makes sense to just file it with the principal brief rather than waiting for the reply. And by principal brief, I mean with the initial brief or with the answer brief. But again, there might be case-specific reasons you don't do that, but the absolute deadline is by the due date for the reply brief to be filed. When you're looking at costs from an appeal, those will be sought in the trial court, not in the appellate court. Like we said, motions practice is fairly rare in appeals, so you should always use them sparingly, and always consider whether you can address the issue in the briefing rather than going through a separate motion. And that typically applies to motions to dismiss an appeal. That will be when it raises substantive arguments as to why an appeal should not proceed, because there might be a lack of jurisdiction or some other manner. It's always a judgment call about whether to proceed with a motion or with it by just arguing it in the substantive briefing. When you have a motion that's been filed and you're responding to it, your response will be due within 15 days of the filing date. Replies are not as a matter of right. There must be granted with leave of court. Typically, the court will only grant leave for a reply if there's been some new argument that's raised in the response that could not be anticipated when the motion was initially filed, or some subsequent authority that came out between the motion and the response filing date. That would be a reason for a reply, but it's going to be within the court's discretion to decide whether to allow you to reply. Sort of two bottom lines here when we talk about motion practice. One is that you'll want to see if Rule 9.300 will, if a motion will toll the time for briefing. So some instances are listed. 9.300 has a list of motions that will essentially toll the deadline for the filing of an initial brief or filing of an answer brief or any substantive briefing. And so you'll want to make sure whether or not that is impacted. It doesn't mean that briefing can't proceed for some reason if the motion's been filed. Again, that's a judgment call by the attorneys, but there is a list that will definitively toll the time for briefing. The other thing to think about when you're filing a substantive motion is that appellate courts typically don't assign judges until the case is entirely perfected. And by that, we mean the full briefing is in. So if there's a substantive motion that's filed in appeal, like a motion to dismiss the appeal, that motion might be assigned to a judge, or two or three. It's not necessarily clear with every instance, but a motions panel who know nothing about the case, and they won't be the ones that decide it. Another instance in which this happens is when there's a motion to stay, because there's been an injunction that's filed in the trial court, or that's been granted in the trial court, a motion to stay that injunction. The motions panel that's deciding that at the appellate court level may not be the panel that decides the case ultimately. So, and that might affect reasonably a determination on the merits. So these are all, like I said, judgment calls that have to be made along the way about whether or not to proceed by motion, or rather than doing that, submitting the briefing on an expedited basis.
Okay, we had one question in the chat. I just want to make sure people saw it. If your time for extending the reply brief or the other party's time for extending the reply brief is filed, then yes, you can file that motion for fees up until the final due date for the reply. I'm going to cover pretty quickly the briefing process. So the timing of the briefs, most important, right? Your initial timeframes are 70 days from notice of appeal to file the initial brief, 30 days from the filing of the initial brief to file the answer, and 30 days from the filing of the answer to file the reply, obviously subject to extensions. I will say this, the appellate bar is very refined and understanding of extensions, much less so than the trial court bar. So it's a little bit frowned upon to object just for the sake of objecting to an extension. The court understands briefs take a long time and require a lot of work. 9.210 is going to give you your formatting and content requirements for all briefs, so you want to check that. 9.100G is going to give you your formatting and content requirements for writ petitions. And again, check the court's website. Like Brandon mentioned, the 6th District has added additional requirements on a jurisdictional statement and a preservation statement. So they can alter these and they will strike a brief if you haven't complied. So important point. I'm just going to run through three, I think three slides that are kind of my best, our best tips for brief writing. Number one is an introduction. I know you have the summary of the argument, but if you're a reader, you're starting at the facts and you're like, why am I reading these facts? How do I know which facts are important? So what we put in the beginning of the statement of the facts is either an introduction, which was a little bit controversial at the time because there's not the word introduction in the rules of appellate procedure, but there is the word nature of the case, is the phrase nature of the case in the rules. So if you're worried about calling it an introduction, you could just entitle it nature of the case. Typically, we want it to be 1 to 3, no more than 3 pages. That basically says, you know, here's this case in a nutshell. Includes kind of what's important and why you win. We don't put citations in it, but we make sure there's nothing in there that isn't then covered in the statement of facts below that does have citations. So this is just like, we're telling you what the case is about, and now we're going to get into the meat and we're going to have citations for everything. And then we use headings and subheadings to tell the story in both the statement of facts and the argument. And that way, if you look at the index, the table of contents of the brief, you basically know what we're going to say. And some judges actually do that. They'll just go to that table of contents knowing that practitioners are doing this. So here's an example of some of the statement of facts headings that we put in a brief. You know, we had our introduction and we had Stout falls into a manhole on Hildebrand's property while there is an invitee. Stout sues Hildebrand for negligently maintaining his property, and he gives self-serving deposition testimony that's contradicted by other evidence. Hildebrand files an initial summary judgment motion, but after Stout's response, amends it to add new arguments. We're kind of telling the story. It's a little bit argumentative, but there's a very fine line there, right? It's definitely framed in the light most favorable to us, but it is factual. And then in our argument, you're going to kind of do the same thing. So here's an example of our argument. A trial court reversibly erred when it granted summary judgment in favor of Preston, despite evidence he failed to exercise due care and was at least partly at fault for the crash. And then our next subheading, a motion for summary judgment by the lead driver in a rare collision must be denied if there is any evidence of negligence. And B, evidence showed Preston negligently failed to ensure the lights on the trailer were properly illuminated. So again, we're telling the story through our subheadings. If the court is really pressed for time, they can sort of read the subheadings and skim the content in between. And then here's our little not so trade secret, because Brian Garner actually wrote it. So it's not our trade secret, but I would say anytime I write a brief, I am looking at this structure. I'm going back to it, whether that's an initial brief or an answer brief. I want to have a very affirmative presentation. I want to start with the rule that I want the court to apply. And that might not be a rule that's right in the case law right now. It might be a combination of a few cases and me putting that rule together at the top. But I want to say the law is this. And then, you know, and the law applies when, and then I want to have my facts. Here's the facts that tell you that that law applies. And then I want to have the application. And then I'll get into the defensive. You know, they're going to argue, or the trial court ruled, you know, this way, but here's why that's wrong. So you'll get this in your materials, and I always look at it when I'm writing a brief or a specific argument. So on all your briefs, front load your arguments, write in conformity with the standard of review, tell a compelling story. One of my other things that I tell people is, when you, especially new lawyers, when you're writing out your brief, when you're starting that, you're writing as you're thinking it through. Okay, I found the law and the law says this. And then, okay, here's my facts. And then, okay, now I'm applying. And then I get to the punchline. Think about moving that punchline now up to the top, and then telling the court how you're going to get there. That will, like, the quicker you get that information to them, the better. All right, then on your initial brief, don't let the judges be surprised by something in the answer brief. If there's something bad for you, don't let the other side tell them first. It would be my main advice on that. On the answer brief, avoid the urge to write defensively. You definitely have to address the arguments, but start, if you can, with why you win, state your affirmative position, and then address their arguments. And then finally, on your reply brief, you can't raise new arguments in reply. I mean, you can try, but they will probably not be accepted.
Don't try. Don't
try. You really shouldn't try. But you know, I know practically, I know the itch will be there sometimes. And then just be short and direct. And then file any request for oral argument on or before the due date of the reply brief. And again, yes, if reply brief is extended, that extends your time for that.
Right, real quick, I'm going to run through oral argument, because sometimes you find yourself with less time than you anticipate at the outset. 15 to 20 minutes, depending on the court. They'll let you know in the order that sets the oral argument. When you're preparing for oral argument, it's always critical to have an outline. I understand a lot of us read the briefs and think, oh, I say I can do this from memory, and I'm just there to answer the court's questions. But when you have an outline, there's certain things that help frame exactly the narrative or argument you want to present to the appellate court. And one way to do that is through an opener. Exactly 15, 20 seconds, 30 seconds, why you win, what you want to say to the court, what you have to say to the court before they can start peppering you with questions. This is an appeal from summary judgment. That summary judgment should be reversed for X, Y, or Z reasons. Here's why. And then in the instance in which the court has no questions, you're prepared to go and explain X, Y, or Z reasons. When you're preparing your outline, also something to think about is boiling down your key legal arguments and organize them to hit the most compelling and important points early, especially as the appellee. Sometimes the way that you're preparing for oral argument is, well, there's 4 issues on appeal, and none of them have anything to do with each other. So I have to prepare individually that the appellant's only going to focus on issue 1, 2, or 3, or 4. And then I've got to immediately go to that. So having an outline that's ready to distill the key legal arguments For any of them that get brought up, any of the ones the court focuses on, you'll be ready to just jump into those rather than thinking that they're going to go chronologically from 1, 2, 3, and 4. And then it also gives you a closer. Like we said, sometimes time runs short and you want to be ready to tell the court the exact thing they should be thinking about before the case ends. And so you're having a short wrap up that tells the court the exact relief you want: affirmance, reversal, and remand, for a new trial, for a directed verdict, whatever it is. It will definitely be helpful if you're running short on time. This is trade secret. Schedule prep sessions starting a month in advance of argument. That's what we do. It's just a matter of practice for a number of appellate attorneys. And so that they can have sort of free-flowing discussion with the people who know the subject area, know the case. It helps you consider your strongest and weakest points and any theme you can draw out from the argument. Having those discussions certainly helps. We know people moot, and that's perfectly acceptable too. But even if you're going to have a moot, doing those prep sessions in advance, either on your own or with your colleagues, whether it's colleagues in your office or subject matter experts, whoever you can turn to for this, certainly helps before doing that moot, because if you're going to do one, you want it to kind of be as similar to what your argument will look like close to the OA. One other thing is to think about every question you might get asked, good or bad. If they're the softballs, it's best to have answers to them. If they're the hard ones, it's also helpful to have answers to them to the extent you can have an answer to them. And then figuring out, what are your transitions? If you get a hard question, can you turn it into a transition to your strongest point or your softball? So you'll be able to figure out your pivot points by kind of going through that whole list again and again and again. And then that's where, having these discussions and moots help, because you'll be able to discuss with them, with the other people that you're working with, exactly what additional questions you may not be able to anticipate on your own. Practice pointer here is Westlaw and Lexis make it really easy that once you get your panel assignment, to be able to look at what the judges who are assigned to your panel have written on the topic. After OA, or if there's no OA, eventually there will be a decision that's made on the appeal. We can't tell you how long. That varies by panel, judge, court. But what we can tell you is that presumably a decision will be issued. It can be as quickly as 2 weeks from the oral argument, and that's usually through a PCA, per curiam affirmance, which is just per curiam affirmed by the panel, nothing else. Maybe sometimes a citation, but usually just affirmed. State appellate courts do have an internal deadline that cases should be decided within 90 days of oral argument, or if there's no oral argument requested, or if it's been dismissed from the conference, what's called oral argument waived, that within 90 days of either of those events, that a decision be issued. Well, like I said, we can't tell you how long it will take. Cases do take longer than 90 days. From that period, sometimes it just depends, and typically that might be because there might be split panel, multiple decisions being written, or it's just a complex case that requires a lot of review of the record or review of the case law. It might be a novel issue. Typically, the court, once it issues its decision, but certainly before it issues a mandate, will issue an order on any motion for attorney's fees that's been filed as well. After the decision's been made by the trial court and filed with the parties, there's 15 days for a party to file a motion for rehearing under 9.330. There are very limited grounds for rehearing. It's that the court overlooked or misapprehended a point of law or a factual part of the record. If the decision states that something in the record says X and the record definitively says Y, no matter how you view the evidence in your favor or in the other party's favor, and it definitively says something else, and that fact mattered for the decision being made, that it was integral to that decision or it was relevant to it, that would be a basis for rehearing. The court said case law said one thing, it definitively says another, that would be a basis for rehearing. These are rare. can't argue that motion for rehearing is not used to argue something that was raised in the briefs but decided against you. That is not the basis for rehearing. It might be the basis for other decisions or other post-decision motions, but it's not a basis for rehearing by the panel. It's a very narrow basis. When you're looking at a case that has a split opinion, or it by implication creates a conflict, that would also be a basis for one that's, I guess, vulnerable to rehearing, particularly the implication of a conflict that's not addressed in the opinion itself. Another DCA goes another way. That would be a reason why. You can also seek rehearing of orders, not just decisions, but orders entered by the appellate court, but that would also be an exceedingly rare avenue for relief. And those kind of orders we're talking about would be motions for attorney's fees, motions to dismiss, motions to stay. Those would be reasons, substantive rulings that you could seek rehearing.
All right, a few other post-decision motions that you can file and consider. I would think rehearing is the most common, but there are a couple asking for a written opinion. So I've seen these granted. They're narrow grounds. You must certify in your request that there's either a legitimate basis for Supreme Court review, and you have to explain what that review would be, or that there is a need for an explanation for an apparent deviation for precedent. If the court doesn't think they've deviated from precedent, that's a little hard to walk that line. But if you think that maybe they've overlooked some case that they appear to have deviated from, hopefully a case that was cited, because if it's new, then or something that just cropped up in their opinion that maybe was a side issue. Or a need for guidance for the parties or lower tribunal when an issue is recurring, a first impression, or subject to conflicting decisions. So rarely granted, but every now and then. Okay, next we're going to do the clarification. You have to state the points or fact of law that need clarification. I've seen this done to kind of correct misnomers or mistakes. You don't usually want to seek, except as possibly an alternative to rehearing, as a like, well, if you clarify this, you might come to a different decision. So I don't see these often, but there is a place for them. Certification, you want to seek certification of a conflict of decisions. Remember, Supreme Court jurisdiction, they can take decisions where there's a certified conflict or that an issue is of great public importance. So you have to explain that, why that is true. But it's only useful if you really want to take Supreme Court review. If you don't want to take Supreme Court review, this is a meaningless motion. And then tailor your arguments to why the Supreme Court would find the case compelling to review. Rehearing en banc is subject to its own rules. It requires you to show it's a case of great exceptional importance or a need to maintain uniformity of the court's decisions, So you have to show that there's some kind of concern about uniformity with this opinion. The court can grant rehearing on its own, rehearing en banc on its own, if it decides it wants to recede, for example. Otherwise, you file the motion and sometimes if your panel was divided, that might give you a hint that there might be other judges who would disagree. And it's, again, very rarely granted. And one of the reasons is the court will actually vote on whether or not they want to go en banc, and you need a majority. So on your larger courts, you've got to convince quite a few of them. And then post-decision motions, just generally, you can respond to them within 15 days. Don't over-dignify them, right? You get this very long 25-page motion that's just re-arguing everything in the briefs. You can file a 3-page reply that says, basically, this is re-argument and improper. And once all the post-decision motions are decided, or when the time elapses, then what you will get is a mandate, if it's a final appeal or a non-final appeal, not writs. It's just a single document. You'll get it and it returns jurisdiction to the lower court. No mandate in writ proceedings.
So as Kristen mentioned, there's the opportunity for further review after a DCA appeal. And so it will only lie, as we talked about at the beginning of the presentation, if one of the limited jurisdictional bases exists for that review. If the Supreme Court's jurisdiction is one of its discretionary jurisdictions, you file a notice to invoke discretionary jurisdiction within the district court within 30 days, and then briefs will be filed on jurisdiction in the Supreme Court. In mandatory jurisdiction cases where the Supreme Court must take jurisdiction, you file a notice of appeal within 30 days. If this is a case where there is not an avenue to the Florida Supreme Court, but there is for some reason an avenue to the US Supreme Court, you file a petition for writ of certiorari in the United States Supreme Court within 90 days of the final judgment of the highest state appellate court. Or if this is a federal appeal, you'll just proceed by petition for writ of cert through after the Federal Court of Appeals decides the case.
All right, then just a few practice pointers on these last slides. Sorry, we're running a little bit over, but a lot of information to pack in. You're trying to advise your client about taking an appeal, and I think one of the things that you have to talk the most about is expense, even for or maybe sometimes even especially for an indigent client. The party has the right to seek review, may seek determination of indigent status with the clerk. And so you may get those filing fees waived, but that will not cover the cost of transcripts. So we've been looking into this I talked to a little bit about at the Florida Bar's Appellate Practice Section meeting. There are sometimes grants available for those transcript costs, but it doesn't seem like there's a really good avenue for that yet. So the section's going to look into it, but remember that your client may have to bear, or your organization might have to bear the costs of the transcripts. Stay pending appeal could require some sort of security. That's a general rule, that they won't stay unless there's some protection because the judgment's presumed correct. And then, is there any exposure to your client having to pay the other side's appellate attorney's fees if they proceed and are not successful, or in a family law case, if they're subject to fees as the party with more financial means?
Other considerations are the time and a delay involved with an appeal. Appeal, generally speaking, could take about a year when you consider all the briefing, the extensions, the oral argument, deadline, or the decision after oral argument, any post-decision motions. Everything we've talked about could take at least a year. So can your client cope financially while the appeal is pending? Can you get a stay of the underlying order that might be adverse, or proceed with it? Can someone proceed with enforcement of that order? And then in a non-final appeal, one thing to think about is, will the appeal put a halt to any progress that can be made in the trial court? We see that definitely with certain instances of non-final appeals. We talk about jurisdiction. So these are things you need to keep in mind of whether or not an appeal is worth it, or at that point done properly at that time. The emotional toll from a lack of resolution, obviously an appeal gives hope, and it may be warranted hope, but it does have an emotional component to it, and leaves things continue to be up in the air. So we see in certain cases where an appeal just doesn't proceed under those circumstances. Also, when you're looking at practical considerations, something to think about is what an appeal will get you. A decisive win is not always common in an appeal. So if there's an appeal from a final judgment after a hearing or trial, and it's based on evidence that should not have been admitted, then the remedy is going to be a new trial, to do over. So it would be to revisit, and the same thing with pretrial rulings. If the court applied the wrong standard, the remand is what will happen under the right standard. So something to think about is, can you ultimately succeed if the appeal comes out favorably? Another thing to think about is that a win or a loss sometimes results in a published opinion. That is precedent. So some issues don't get appealed because if the ruling could be adverse, it sets bad precedent in a number of other cases. I don't think that's a strong reason not to appeal specifically in any case. We represent clients, not legal issues. but obviously it's something to think about in the broader scope of our practices.
Let me add one little comment on that, because there's
Yes.
another reason I put that line in here, and that is because in family law cases, your children may look up your family law appeal. So my husband's parents had a divorce case, and so he can read now about the child support arguments that they made when he was a child. More interesting was a case that was at the Second District Court of Appeal when I was there, and it was a paternity case. And the biological father, well, it was a parentage case, and the biological father was actually not a party. And a published opinion would have revealed a lot of facts that, if found, might have seemed suspicious to some people. So there can be personal reasons to not want to have that, and then maybe you're going to be moving for, changing the names or protecting some privacy issues.
Mm-hmm. Lastly, we threw in some additional resources on appeals. The appellate practice section of the Florida Bar has a pro se handbook. Frankly, this is not just for pro se litigants. It is a fantastic resource on everything related to basic appeals. And so we're putting the link in our presentation so that you can access it. And it may just be a first line to answer any questions that you have. The appellate practice section also has a pro bono committee. It's a committee of attorneys, members of the APS, that are dedicated to handling pro bono appeals and helping provide guidance to legal services and agencies that you all work with. And so if you have any questions for them, we've provided a link to their work as well. But we appreciate it. Kristen, do you have any parting words?
I do not. Thank you so much for having us.
I know we went a little bit over, but totally worth it. A big thank you to both of you, to Kristen and Brandon, for sharing all your knowledge and experience with us today. My background as a legal aid attorney, if I heard the word appeal, I would just freak out and start running. I don't think that's the same after today. Your practical insights on these practical considerations were amazing. This is a great resource for public interest attorneys and civil legal aid attorneys. So I know we will share a copy of this recording with everybody that registered. You're gonna get a copy with everything. There was one last question that came in through the Q&A, and I believe it was answered, but I still want to read it out loud for the benefit of the audience that is listening in. And the question was, how frequently are oral arguments held if requested?
Right. And I said, I did post in the chat the answer to that. It really depends on the court. The Second District Court of Appeal will pretty much grant any request. For a while, they weren't doing non-final appeals. They were making you file a special motion for those, but now they'll grant them a lot in the non-final appeals. Sixth District, we've seen them that kind of as a matter of course, they seem to be granting them, but with a caveat that they can withdraw them, and we have seen them withdrawing them. So it really does depend on the court. And, if you have any questions about specific courts, sometimes, definitely can ask around and find out like what their practices tend to be. It might also be in their IOPs on their website or in their administrative orders. So.
All right, and I guess before we wrap up, I did post it in the chat, but the code for this CLE is 2410925N. I'll drop it one more time here in the chat. It will go out in the materials via email. And Brandon and Kristen, thank you again for this amazing presentation. Everybody have a great day, the rest of your day.
Thank you.